Essentials of a valid contract.
According to Section 10 of the Contract Act, all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object and are not expressly declared to be void. 2. Legal relationship. The agreement must create legal relationship between the parties. If there is no intention on the part of the parties to create legal relationship, there is no contract at all. Agreements of social or domestic nature do not contemplate legal relations, and as such they do not give rise to a contract. For example, an agreement to dine at a friend's house is not an agreement intended to create legal relations and, therefore, is not a contract. But an agreement to buy and sell goods are agreements intended to create some legal relationship and, therefore, contracts. 3. Lawful consideration. Consideration means something in return. Every valid agreement must be supported by consideration. An agreement without consideration is void. The consideration need not necessarily be in cash or even in kind. It may be an act or a promise to do or not to do, but it must be real and lawful. An agreement with unlawful consideration is void. 4. Lawful object. The object or the purpose of the agreement must be lawful. It must not be immoral or illegal or opposed to public policy, otherwise it will not be enforceable by law. 5. Competent parties. At least 2 parties are essential for every valid contract. Further, the parties must be legally competent to contract. If they are not competent, the contract is not valid. Every person is competent to contract if he has attained the age of majority and is of sound mind. 6. Free consent of parties. The consent of the parties to the agreement must be true, full and free, otherwise the contract is unenforceable. Consent is said to be free when it is not caused by misrepresentation, fraud, undue influence, or coercion. 7. Certainty of terms. The term of the agreement must be precise and certain, otherwise it cannot be enforced. According to Section 29, agreements, the meaning of which is not certain or capable of being made certain are void. 8. Possibility of performance. The agreement must be capable of being performed. An agreement to do an impossible act cannot be enforced. Law does not compel anybody to do an impossible act. 9. Compliance with legal formalities. According to Indian Contract Act, an agreement may be oral or in writing. Where the agreement is in writing, it must comply with the necessary legal formalities as to writing, registration, and attestation. If the agreement does not comply with the necessary legal formalities, it cannot be enforced by law.